everyone, and welcome to our Halloween-themed webinar today, where we'll take a spooky look at some horror stories of handshake agreements. And I'm sure we'll learn a lot from this as well. So thank you all for joining us today. As normal, we will be recording this session, and we'll send out an email with a link to the recording so you can have access to that material later. We also welcome all of your questions, so feel free to type those into the questions tab on your GoToWebinar panel, and we'll make sure we save some time for those at the end. If your questions are very specific to your situation, we ask that you would make an appointment with one of our consultants, which you can do through our website, and I'll put a link to that scheduling page here in the chat. So I'm Hannah Curtis. I'm a coordinator with the North Metro SBDC. I'm joined by John Hovey, Special Projects Consultant with the SBDC, and we're so excited to introduce to you today Samantha Peaslee, our presenter. Samantha is an attorney with Polaris Law Group and legal consultant with us here at the SBDC. So Sam, we are all excited to hear what stories you have for us today, so I will turn it over to you now.
Well, thanks. Thank you so much. I'm excited to be doing this. This is a Halloween tradition that I really enjoy. Oops, skipped ahead a little bit. I am a fortune teller today. I don't know if you can tell that one. I have my crystal ball. And part of this is because, one, it's sort of inspiration from a lot of those Halloween themed movies, TV show episodes where somebody kind of can look into the future and see those scary stories. But it's also because I've seen what happens when you don't write down your agreements, and I can see what will happen to you or what might happen to you if you don't do yours. So happy Halloween. Get that started off on the right note. And let's talk about some scary stories. And yes, this is one of the, usually I start my presentations out by saying, I know I'm an attorney, but I'm not trying to scare you. This is the one presentation that I do that I am absolutely and 100% trying to scare the pants off of you as far as your business goes. A little bit of introduction. Hannah did a great job introducing me, but I also, so we're Polaris Law Group. We serve as general counsel for small to medium-sized businesses. So we've seen a number of scary stories. A number of these are off of cases that are filed in the state of Colorado as well, or in the federal district court for the District of Colorado. Some of them are not. Some of them are ones that I have gathered throughout the years and I've gotten permission to share abbreviated versions of, but other ones you could look up these stories. They are public record as far as that goes. So first type of scary stories that we're talking about deals with a concept called piercing the corporate veil. And if you've heard any of my talks about what your corporate formalities are, then you might have heard me allude to this concept of piercing the corporate veil, or of putting up walls so that people can't pierce the veil. So before I get into the stories, I want to explain to you a little bit about what this concept is. So typically speaking, if you have an LLC or a corporation, or a limited partnership in some sort, there is no personal liability for members, owners, shareholders, whatever you want to call the people who actually own the company. For the officers of the company, that would be the CEO, CFO, president, treasurer, directors. So if you have a board of directors, or if you have a manager, if you're an LLC and you're manager managed, typically none of those people have personal liability, so long as they act in good faith and they act in a way that is consistent to their duty of loyalty to the company. Piercing the corporate veil is what you do to say, oh, barriers aren't there. We're going to reach across. You don't have enough of your walls there. We're going to reach across, grab this individual, pull them in, and make them personally liable for whatever this action of the company is. And here that first line is supposed to say, or insider on the top of it. So it's when you can grab that person and make them personally responsible for the company. Typically, that can't happen. There's a three-part determination on whether a court can pierce that corporate veil. It's a little bit misleading because the first part is then broken into 7 parts, but it is a 3-part test, and that is whether the entity, so whether your company, is the alter ego of the person in question. And there are 7 different factors that go into that. The ones that I've brought up on these kinds of talks before that your SBDC consultants have told with you. The big ones are commingling funds. If you're treating the company bank account like your personal piggy bank, that's probably an alter ego. Do you have adequate corporate records? Are you acting like the corporation has to make decisions independently of you? Are your legal formalities disregarded? Meaning, do you have a filing with the Secretary of State, but you don't have bylaws, operating agreements, board meetings, those kinds of things? And then there are other factors as well. The second part of the test is whether the corporate fiction, meaning whether the use of the corporation was used to deceive someone. And third, whether an equitable result would be achieved by disregarding the corporate form. So meaning would it only be fair to the person who is asking for that to be disregarded to do it? So here, those handshake agreements that we're worried about are the ones between a company and its members, or a company and its officers, a company and its directors. We want all of those relationships to be protected in writing so that we can show, here's the parameters of the relationship, corporation is real. And here's what happens when it doesn't. So 2 scary stories on this one. First is the case of the family business. And I always bring this one up first because it is so common, especially when we get a lot of questions about, okay, so I personally can't be listed as the owner of the business because I have these financial troubles, or I declared bankruptcy in the last several years, or a number of other reasons. So what if my wife just has the business and then I just run it? Well, here's a really good reason why not to do that. So we had a business, and that business was 50% owned by the wife and 50% owned by the mother of this particular individual. The individual was not listed, so they had basic corporate documents, very basic, printed offline, and the individual in question was not an officer, director, or owner of the company. So he was technically not a part of the company. But he was the only one who managed the company on the day-to-day basis. Sometimes he would have the actual owner sign off on things. So for example, if a bank needed something, he would have his wife just sign the check and he'd go bring it in. But he was doing all of the actual day-to-day business, all of the sales, all of the engagements. He paid himself at will from the company, meaning that if he felt like getting money that day, he pulled it out of the company bank account, put it into his own, pulled it out of the company bank account in cash, kept it. And then he would also pay personal bills from the company bank account or from funds that they had immediately pulled from the company bank account. So it would be and sometimes they would mark it off as wife shareholder distributions, but not pay the mom any shareholder distributions, and sometimes they just took it. So he was using that bank account as a personal piggy bank. He wasn't doing it on a monthly basis, wasn't doing it bi-weekly. There was no rhyme or reason to it. The particular deal that got them in trouble and that got them caught, and by them I just mean the particular individual I'm talking about. Wife and mom did not actually get in trouble for this. The particular deal in question was a lease that was going to be for the personal benefit of the individual, but was in the name of the company. Along the lines of they wanted a vacation home. They wanted a vacation home, and he was going to put it in the name of the company so that it would have better tax status, and so that it wouldn't be, he had a couple of other financial issues going on, and he didn't want that house to be attached. So he thought, well, we'll just put it in the company name. Neither wife nor mom was involved in the negotiations. Neither of them was involved in reviewing the lease. And he signed the lease on behalf of the company. And then they ended up, then what happened was he got sued for his personal problems, and they wanted to attach that house. They wanted to attach that portion. The individual was determined in this case to be an equitable owner and to pierce that corporate veil. I'm sorry, I got that mixed up. The last one I said. So it wasn't that he was sued personally. It was the company was sued because they defaulted on the lease and they wanted to catch him in there and catch their regular house, use their regular house. And so the argument was, well, they're saying this is a company, but they're not running it like a company. This is basically his own private bank account. And the court agreed. The company was a sham company. It was there on paper, had a couple of corporate documents, but had never had a meeting. The two purported owners never did anything. They hadn't elected this person manager. There was no accountability for him as manager. He wasn't listed in the company at all. So he was held personally liable for damages. Now, in this case, wife could have been held liable for damages too, because she was letting everything go in there. I think they ended up not making that determination because it was kind of a moot point from a practical matter. But it ended up that the work that they had put in to try and cover it with the company ended up being completely moot, because at the end of the day, if you look like a duck and you quack like a duck, you're going to be considered a duck. And that was what happened here. That's why it's really important to act well in your company and use those documents to show who is in charge of what for what purposes. Another similar case where there was a corporate veil, this was with two companies. So sometimes it's nice to have two of your companies, even though they're owned by the same people, either because they do different things or because you want to keep them separated for liability purposes, or you think that one might be opened up to other people in the future. There's a lot of good reasons to have two companies that have the same owners. In this particular case, the owner had two of these LLCs. One was being sued for its actions and the other was not. One of the, so company A, we're going to call it, had assets that largely was this airplane. It was a private plane, and had the ability to do delivery with that private plane. So they would use that plane for company B's operations. That's allowed. That's perfectly allowed. But the way that you usually do that is you have a contractor agreement between company A and company B, when you're allowed to use the plane, under what circumstances, who's responsible for any accidents that happen while the plane is there, what are you paying that person for being able to use their plane. And you can have reduced compensation for a shared company, but you still need to have some sort of compensation. So somebody sued company B and they wanted to attach company A's plane. Well, the company only had, both companies only had Secretary of State filings, had no other corporate formalities, had no operating agreements, had no annual meeting minutes. The owner regularly commingled personal funds along with both companies' funds. So if company A needed to pay bills and it didn't have enough money in there, he'd take it from company B. If owner wanted to pay bills, he'd take it from company A. So he just kind of used all three like his own interchangeable business accounts, personal accounts. Then they also found that it was thinly capitalized. So thinly capitalized means that there is not sufficient funds to run a company in the industry that you are in on a regular basis. While startups sometimes worry that they're thinly capitalized because they don't have a lot of funds coming in yet, and that can be a concern, this is more of a concern if you are regularly having to move personal funds over to pay company bills, or if you are regularly saying that you don't have enough to pay your bills. If you don't have enough money in there to do what you need to do, that's going to be considered thinly capitalized. You may be able to pierce the corporate veil. There may be tax consequences. Lots of good reasons not to do that. So since the assets would also go straight from the entity to personal accounts that they came in, basically all of this money moving was not documented, never showed why it was going there. So at the end of the day, when the litigation fees were owed, company B lost, and they were able to garnish the owner's fees, and they were able to garnish the fees from company A from the plane. So because even though he had set these things up separately with the idea that company B had more liabilities, will protect the plane by keeping it in company A because he never acted on any of that. Company A and the plane got garnished anyway. So the lessons to be learned from these piercing the corporate veil stories are to make sure that you engage in corporate formalities, which includes having an operating agreement, having bylaws, designating officers and directors, holding regular meeting minutes, keeping your bank account separate. Not being on paperwork is not a protection from the action. So just because you're not on the papers doesn't mean you won't be liable if you're acting like an owner. So if you have 3 of you, 2 of you are owners and 1 of you is just doing a lot of stuff for the company, you better make sure that that relationship is written out. Otherwise, you may be deemed to be responsible anyway. Money should always be tracked and recorded as far as where it's going and why. And ultimately, I said this already, but important to remember, if you look like a duck and you sound like a duck, you're going to be treated like a duck. So before I get into our next set of stories, I see that we have some questions. Why don't we go ahead and do the questions on piercing the corporate veil now? And I can read these, or Hannah can read these. There we go.
Yes. I don't know that we do have questions in right now.
Oh, good deal.
So for those who, if you do have some burning questions, please feel free to type those in. I know Samantha's been doing a great job of explaining this, and hopefully these spooky situations don't come up in our businesses. So yes, anyone who has questions, please feel free to type those in that questions tab there.
Awesome. I saw the general and thought that was that. All right, well then I'm going to move on to handing away your IP. But if anyone has questions on those piercing the corporate veil stories, please feel free to pop them in there and we'll always come back to them. So this is our next category of things that we see scary stories because people just think a handshake agreement is good, and that's handing away your intellectual property. We all have intellectual property. I am a big one on every single business as intellectual property, whether you believe it or not. The question is whether you still have your intellectual property after having operated in certain manners. So most intellectual property requires some action on your part in order for it to stay enforceable, meaning that it's kind of the use it or lose it concept, except for the if you use it without using it right, you will lose it. So with trade secrets, for example, you have to keep them secret. And if you don't keep them secret, you're going to lose your trade secrets. If you have a copyright in something, let's say it's your photos, and you let 200 people copy that photo off of your website without saying anything, but then 201 comes around and you notice that there's somebody who has a lot of money and you go after and enforcing it, you're not going to be able to because you didn't enforce it for those first 200. With trademark, if somebody's using a brand that's confusingly similar to yours and you don't ask them to stop, you don't make those clarifications, you're going to lose the right to that trademark. Patent I don't have on here just because I don't usually do patent work, but similarly, if you don't register your patent, you market it and you don't have those protections in place, well, you may not have that ability to patent it in the future. You may, but you may have lost that right. So we combat a lot of these things through written agreements. So with trade secrets, confidentiality agreements, with copyright, either cease and desist letters, registrations, non-disclosure agreements with the people who work with us, with trademark licenses, so making sure that anybody who is using our mark on our behalf, that we have control over how and when it is used. But here are some scary stories as far as when some IP has been just handed away. So this is a good one, the contract versus the manual. In this particular case, this was not an employment situation. This was a dual company situation. But we do also see this a lot with employment issues. Most manuals are considered policies, and they are not in and of themselves enforceable contracts. They may have terms that are enforceable, especially if they're referred to in contracts, or if they're treated like terms that govern the relationship by all parties, but not always. So a lot of times people don't want a long contract, So they toss things into a manual thinking, well, this will be easier. But if they're important terms, those may not be able to be enforced later. So in this particular situation, we had company A who was trying to sell its products on company B's website. Company B is a big national brand website that sells products. And company A, in order to sell its products there, has to license the ability to use its trademark to company B, because otherwise it won't be able to sell its products on that site. It's kind of useless that they won't be able to be advertised. So company B does enough of this that they have these standard materials. And so they have both a contract, which was a terms and conditions page, and a manual. And the terms and conditions page was within the manual. And so company B, whenever anyone signed up to put its products on its website, would provide out this manual that included a terms and conditions page that said you need to sign this and this is the binding contract. But you know, the question is, what part of that is the binding part? So if the terms and conditions are inconsistent with the manual, what happens? Well, the terms and conditions said specifically that if they were inconsistent with the manual, the terms and conditions controlled, which is not uncommon. So within those terms and conditions, they have a license that was stated to be perpetual, meaning forever, and worldwide. That's a big license, first of all. That is giving away a lot of rights. Licenses can be term limited, they can be situation limited, they can be geography limited. So they can have limitations on how that use goes. For example, only for the following situations. It's perpetual so long as. Nope, just perpetual and worldwide. And then the license had no limitation on how company B could sell or present the items. The manual stated how company B would sell and present the items, but there was no limitation that the license would go away if that happened. So then the parties signed this, and company B then started, this was probably 10 years into the relationship, so it went fine for quite a ways. And then at some point, company B started changing the way that they were doing their advertising, and they started placing company A's mark next to competing brands with a similar version of that mark. So this in particular was a video professor program. So they would place the video professor next to virtual professor and next to professor video. So it would just have all of these very similar things side by side, because that is how people like to search. But company A was very angry about this, because it's like, no, we had a license. You're supposed to prioritize our mark. So company A terminated the contract, closed the terms and conditions, stopped selling their brands on that website, except that company B continued to use that mark and continued to use it in comparisons and continued to use it, would get it from third parties who were selling resold versions of their mark. So company A comes in and says, you can't do that. We terminated the contract. They said, no, you terminated the contract, but the license persisted because it's perpetual and worldwide. And they said, wait, no, the perpetual and worldwide, that's pursuant to our license. No clarification as far as that goes. All you have is this one-page terms and conditions, and then everything else is in the manual, which is completely unenforceable in court. The court upheld this. The court upheld the perpetual and worldwide license. Company B won on this one. And they said, your terms and conditions state that this is perpetual and worldwide. Yes, the manual says that here are the conditions under which this goes, but the manual is not binding. So, and this says in it right here, manual is not binding. So if you wanted those to be binding terms, you needed to put them in the enforceable contract. So I know this one's a little different because it's not quite a handshake agreement, but I think it's an important one to put out. Just because you put something in writing doesn't mean that if you don't put it in a contract that it will be enforceable. So you have to know where your terms and conditions are, and if they are important to you, they need to be in an enforceable contract, and they all need to be in the same place. So because basically what happened here is, because it had given this perpetual license to company B, it no longer had control over it. It lost its trademark because it was now being used in both of these places. It had no brand control anymore. Basically had to do a full rebranding of its company, and this was legally upheld. So that's always a scary story for me, is that it's written, but it's not written in the right place. And so you completely lost your trademark in that situation. There's also the case of the unsecret secrets. How many people, I always say, how many people can you tell a secret to and it still be a secret? Theoretically, none. If you tell one person, it's no longer a secret. But if you tell one person, you can probably still keep it fairly protected. You tell two people, it's not a secret anymore. It's done. It's gone. So with trade secrets, you always want to make sure that you keep it protected, you keep it secret, you let people know that it's a secret. In this particular situation, we had a consultant, small business, who had a number of items that were necessary for their business. It was a training business. So they would have one-on-one meetings with clients. They had agreements with clients that they would go out for a year, and they would give the clients a bunch of these materials. They also had a bunch of these materials that they had built up over the years that kind of told them what came next and how best to do these. Pretty typical, right? In a consulting sort of company, you have all of these things that you've built up, this vast quantity of knowledge, some of which you give to your customers and some of which you don't. At some point, 15-ish years into the business, the consultant took on a mentee who had gone through this training with her as a client and now wanted to learn to do this herself. Consultant agreed that they would do a monthly lesson cost, and they agreed that the mentee would now be able to see all this backroom stuff that consultant used, but that they would only use it for learning, and that when they went out to go start their own company with this, that they would develop all of their own, and that they knew that some of this knowledge would transfer over, but that they were not allowed to use any of the client information or anything like that on there. But this was just an understanding. This was just a handshake agreement. They never wrote this down anywhere. Yes, the mentee paid the monthly cost, but that was it. There was no invoicing. The consultant would always give its clients some payment terms and a waiver, but no confidentiality agreement. No, my stuff is copyrighted. No, you can't use this otherwise. I think there was a little bit of a, if you want to use my materials in any way, ask me, but that was it. So not even the stuff that was given out to the clients was protected. So at the end of the agreed upon 6-month mentee period, the mentee left to go to another state and start their own consulting business. They wished each other well, all good. And then 3 months later, the mentee began using a version of the consultant's same trademark and posting the materials from their lessons as blog posts. And they started doing this basically just pulled directly from the consultant's materials and would put it in a blog and kind of dress it up a little bit, maybe sometimes, but there were full paragraphs that were identical. The consultant figured this out because they were looking for something at one point, and it was found about a month, maybe 6 weeks into it, and confronted the mentee. And the mentee claimed that since they had never registered the mark with the trademark office, that it was fine to use it, and that nothing on the materials that she had received both as a client and as a mentee were confidential, that this was all stuff that she had been giving away for free for years. And so clearly she could use it. And sure enough, nothing was marked, nothing was confidential. They ended up settling this out of court, But basically the consultant lost the exclusive use of this material. And if the consultant had gone to court, the court likely would have found that these were not trade secrets and that she had given away some of the copyright by not protecting it through copyright. So they settled it out of court, and they could both use it as far as that went. The consultant got to retain their right to the trademark, but that was it. So because the consultant thought they were being nice, they were taking on this mentee, they weren't making them sign anything, they were being nice with their clients, they weren't making their clients sign more than was inconvenient. Consultant basically lost 15 years of knowledge that was exclusively theirs and was no longer exclusively theirs. And so do they still have that knowledge? Yes. Is that consultant still valuable for who that consultant is? Yes. Can't put the secrets back into the box, can't put Pandora back into the box. So the lessons to be learned from these stories are that if you have secrets in any way, have agreements. If you have anything you don't want to be lost, have agreements. License in a way that allows you to control the brand. License in a way that allows you to pull back that permission if something happens that you don't like. You may lose your intellectual property forever if you do not protect it. And handshake agreements can turn on you. It doesn't matter how long you've known the person, how great of a relationship you have. Handshake agreements can absolutely turn on you. Before we go into the partnership horror stories, any questions on handing away your IP or on the piercing the corporate veil?
Yes, yeah, we do have some great questions in here. So on that IP section, we have a question. She says, I'm curious about business names. If you have a company registered with the Secretary of State, for example, Bradshaw Construction LLC, can you do something to stop people from registering Bradshaw's Construction LLC or Bradshaw Construction Inc., you know, those similar types of names? Can you do anything about that?
No, but maybe. So I'm going to say no, but maybe. And I'm going to say no first, and then I will explain when there are exceptions to that rule. Generally speaking, while you're not supposed to be able to have names that are identical or near identical on the Colorado Secretary of State website, there is no screening process for that. The only thing that they will not let you do is something that is literally identical. So if you had Bradshaw Construction LLC and Bradshaw Construction Inc., Secretary of State site does not pick up on that. It allows both of them to go forward. So from a practical matter, no. So then the question is whether you can stop them based on trademark. Trademark you can get whether it's registered or not. Trademark you get through use. So if you are using a mark and somebody's using a confusingly similar mark, you may be able to prevent them from using that mark if you were using it first in the same literal area. So if you were using it in Fort Collins and they're using it in Colorado Springs, you don't get to prevent them from using that. No go, unless you have it federally registered. However, the only way you would be able to really enforce that is if it is truly confusingly similar. And so for Hannah's example, if you have something like Bradshaw Construction, you will never be able to enforce limitations on that for two reasons. One, it uses a name. Anytime you're using a name, you cannot stop somebody else from using their name in their business. So if you have a name like Smith or my married name is Brown, that's not a great one. Because if I want to do Brown Law Group, I can't stop other people from using that because it's an exceptionally common last name. And then Law Group is what I do. I can't stop other lawyers from saying what they do in there. So if you have a name plus what you do, you will never, ever, 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 ever be able to stop other people from using it. And I apologize for that one. There are others that are kind of a closer call. So if I just said, you know, let's say we decided to be legal heroes. Okay. So to the extent that our name says that we practice law, I can't stop other people from doing things that are close. To the extent that there is an identical legal heroes and I was doing it first, I might be able to stop them. But to the extent that somebody is then, you know, legal heroes of family law, and we're clearly a business law group, I might not be able to, because that might not be confusingly similar. So that was a very long answer to the question, but the short answer is for very what we call descriptive names, you don't have any protection over them. The more arbitrary your name is from what you do, the more protection that you may have, but it's not with a pure filing on the Secretary of State. You would have to use trademark law.
Great. Well, thank you for getting into some of those caveats. That's really helpful. So going back to piercing the corporate veil, this question from Carol says, if you don't have any revenues yet and use personal funds to cover purchases and investments, should you record that as a liability then that the LLC owes you as the owner?
Yes, great question. So we recommend doing this in one of three ways. If you're going to be at your in your startup phases, if you currently are not getting enough income in to do things. Way number one would be to do a capital contribution into your company. So as an owner, when you put money into your company, it gets converted into the value of your company. So you make an investment, that investment stays in the company. It does not get paid back. The idea is that it increases the value of your company and you get paid back in profit over time. It would not get paid back until you close or sell your company. So for example, if you know that you're going to be needing a lot of expenses over say that over the next few months, you know you're going to need $10,000 worth of expenses. We would recommend putting that into your company as investments in chunks, tracking it as investments so that you know that this is what your value in the company is, and knowing it's not coming back. If you need it to come back, but don't need it to come back immediately, we recommend giving your company a loan. You execute a promissory note, you put a big chunk of money into your company. Again, you don't want to be nickel and diming that if that's the case. You put that $10,000 in, or $5,000 in this month, $5,000 in next month, and you set a date in the future when your company has to start paying you back on a monthly basis, and you have to be good about paying yourself back. You have to treat it as if this were a third party that you were taking a loan out from and that you're paying yourself back. You don't have to do interest if it's a loan to yourself, or if it's a loan to your company. Sorry, it's not a loan to yourself. If it's a loan to your company, you don't have to do interest, but you do still need to track it, and you do still need to do regular payments. And we recommend that especially if people are giving up a salary to start their company, as a good way of getting those regular payments back when you're not really sure yet what your salary is going to be. The third way, and this is my least favorite, but it's perfectly fine for especially if you don't need those big chunks of money, it's just reimbursements. If you pay for something for your company, write that as a reimbursement, and your company needs to, you provide the company the receipt, you provide them the date, you provide them the reason, company needs to pay you back within 60 to 90 days, and that needs to be tracked. So those are the three ways that we recommend dealing with that limited capitalization or the thin capitalization. All three of those are generally acceptable accounting methods for dealing with thin capitalization, and those will avoid piercing the corporate veil because you're tracking them and you're making sure that you're using a consistent habit.
Great to know. Yeah, thank you. That was a good question. So thank you, Carol, for that. And those are all of our questions on these first two sections here.
Great. Well, this is our last one. Hope I haven't scared anyone so badly that they're running away from us at this point. And these are partnership troubles. And quite frankly, these are my least favorite to deal with, just because they can be really heartbreaking on these ones. The other two, they're never fun, especially because they're totally preventable. But most of the time you can deal with them. Partnership troubles are emotionally devastating. And so really recommend always putting these kinds of things in writing so that you're not having to try and make those emotional decisions while you're dealing with things like this. So partnerships are created automatically. Partnerships, you don't have to do anything fancy. You don't have to file with the Secretary of State. Once 2 or more people are conducting business together, that is a partnership. That is the default. So absent anything else, that is what is happening. If you want it to be anything else, employment, contractor, LLC, investor, like anything else other than a partnership, you need to write that down. Otherwise, you may have somebody who you thought you were just coming in to help you with your books every couple of weeks, and all of a sudden they own 50% of your business. And that's an extreme example, but that is about to be one of the examples that we talk about. So a partnership, having partnerships that were unintentional and that we have to untangle, it's kind of like common law marriages. You never mean to get, well, sometimes you do mean to get into them. That is part of the point of the common law marriage, but you never got married and now you have to get a divorce is kind of the idea with the partnership troubles. Additionally, unless you specify that you're a limited partnership, when you have a partnership, all partners are jointly and severally liable. So that means that if I'm going to use, I typically go to my cupcake shop as my business example. So if you own a cupcake shop and you hire somebody to come in and help you run front of house, you don't have any written agreements with them, and you're paying them, but at the same time, like, it's not quite as consistent, and they help you with a lot of things that a normal just front of house cashier wouldn't help you with. And then one day you come in and all of the money is gone and this person has run down to Mexico. If they took that money and that money was owed to this third party, let's say it's the person who supplies you your ingredients every week, and so you can't make that payment, and they sue you for that payment, they sue you for collections, you're jointly and severally liable, which means you can't just say, well, they went off to Mexico, it's not my fault. No. You are responsible for their behavior as well, and then it is your responsibility to go after that. So this is why I don't like when partnership issues come around, is because that can be a really frustrating and difficult process. So really important to have documents with your business partners in whatever form they may take. So in this is the case of the 50% contractor. So we have this situation. We have somebody with a bar, small bar, used to be, pretty thriving, was running into some hard times, and this person just wasn't, they were a great bartender, and a great small-time chef. So they had kind of a rotating 10-item menu that they would do that was really high quality, really good, but they hated running the business side of things, as I'm sure many of you can relate to. So she hires on her cousin and her husband for some help with the marketing. She's like, I have a great, concept. When we have people in here, it's fantastic. I just can't get new people to come, especially with this kind of very narrow concept. What do I do? And her cousin had used to work at a marketing firm, had been taking some time off, brings them in. They all agree that the cousin and the husband will be contractors, that they'll be contractors in for marketing. They'll be paid on a 1099. They don't write any of this down. They just agree that this is what they're going to do. So the cousin and husband do help with marketing, and over about 6 to 8 months, they increase attendance significantly. The bar is full every single weekend night. It is 75% full on the weekdays. They're starting to talk about opening into a new space. It is just booming. And after about a little over a year of doing this, the cousin and husband start doing special marketing events just for their friends. And they're basically private parties, and they go behind the bar and they take tons of booze at each of these things. They wreck the kitchen. They just kind of go back there and make whatever they want with whatever's back there. And it starts with, they do this like once for somebody's birthday and the owner looks the other way. Then they do it for somebody else's birthday and the owner looks the other way. Then these are starting to happen like once a week. And this is a very big problem, and it's starting to hurt them, and they're starting to lose some money, even though they had been, looking at expanding. So the owner asks the cousin and the husband to stop, and they say that it's part of their rights in their role in the company. And so owners are, no, you're contractors. That's not part of your rights. And they're like, well, no, we grew your company. We grew your company 200%. I'm making up that number, but it was close to that. We grew your company 200%. You've been paying us less than what you would normally pay a marketing firm for this. This is part of our compensation. This is part of our rights. We're co-owners. And owners like, no, I don't think we are. But they end up getting into litigation over this, and they hadn't been paid what their standard in the industry would be. And the owner had been giving them more and more individual responsibilities that were not just marketing, but were also the purchasing items for the bar, and helping out with some of the accounting things and some of those other roles that wouldn't necessarily be given to a 1099 contractor. And they cleaned up the bathrooms at the end of the night. And they were ultimately determined, and the owner had no corporate documents. They had the single filing, they had their liquor license, they had those kinds of things, but they had no documentation of ownership. And the cousin and husband had put a lot of money into this as well. And so it was determined that the cousin and husband had invested sufficient to make them 50% owners. And each of them were given a 25% ownership, and they actually had to dissolve that partnership because they had been working together. And so then it was just all right, well, you're both saying this is called something different, so let's strip out all the titles and look at it, and what does it look like? And it looked like ownership. So the owner lost 50% of her bar, 50% of her profits. For that, ended up having to close down the bar. Like I said, I don't like these. They're scary stories, but they're also sad stories. So that is why you should always, always, always get those kinds of things delineated. This was one where we had some intentional partners. They meant to be partners. They started their company in the 1980s together. So, and in the 90s, for the first time, sometime in the 90s, their accountant told them they would need an agreement. And they're like, oh, well, I suppose, I mean, we've been doing this fine together for 12, 15 years. Like, I guess, like, if you're telling us we need it, whatever. So they found some online, and they actually found, they decided they were going to be an LLC. They found an operating agreement online. They found a partnership agreement online. They found a buy-sell agreement online, a couple of other documents, printed them all out, changed a couple of things in there, but mostly just printed it all out as it is, signed it, never had an attorney review it, never had their accountant review it either, which was important because the operating agreement said that they would be being taxed as a partnership, but the accountant had been taxing them as an S corporation for, at that point, several years, continued to do that for several more years. After that point in time, in the, I think it was 97 that they did that, they never looked at any of those documents again. They signed them all, they're validly signed. At some point in there, that accountant who originally told them to do that retired. They got a new accountant, and in the early 2010s, the issues with that accountant reached a head and caused problems, such as significantly late filings for like 4 years in a row. They had to revise and correct several things for multiple years in a row. It messed up their personal taxes. At one point, the person who had not hired the accountant said that they wanted to fire the accountant. The other partner who had recommended the accountant took this personally. They ended up fighting. The partner who had hired the accountant left the company. Well, after leaving, and by leaving, I mean sent an email and said, I quit. I never want to deal with you again. You've screwed this all up. and I'm going and starting my own company that does the exact same thing but better. And left in a blaze, sent that email out. And after he would leave, he would check the bank account every day. And as soon as money would hit that bank account, he would take it and he would transfer it out to his new company, which was fun. So the other partner came back and first tried to go to the bank saying with that email and said they quit. We need them to do this. The bank takes a look and says, no, they're a full owner. We need both of your signatures. And he's like, he won't come in to sign. He tried for about a month to try and get him to come in to sign. He's like, no, I don't need to do that. I'm entitled to this money too. I'm not going to do that. But the bank wouldn't close the account because their operating agreement said that both of them needed to be there to close it. And they were both owners. And the email itself was not sufficient for them. So they get to dispute resolution and it comes time to review the documentation to figure, all right, so you guys have all these documents, fantastic. We can figure out who is responsible for what. We can figure out where you're going for dispute resolution. Because they had printed all of these out from different places, they were from different states. A lot of it contradicted each other. There were 4 different dispute resolution processes between 5 documents. And some of them internally contradicted each other. So some of them said you had to be here, some said you had to be here, some said arbitration, some said litigation. Some said you absolutely must do mediation first or it's bad faith. There were 3 different processes for how to buy out a partner or close the company. So basically, we couldn't rely any on the documentation, so it was all useless. It was basically useless pieces of paper that meant absolutely nothing because all of it was signed simultaneously. Usually what we do as attorneys, if that's the case, is we start to look at, all right, what was the most recent that can go? They were all signed and dated on the same date. They had done them all on the same date. One thought that one was responsible for the taxes because they were named as a tax matters partner. The others thought the other one was because they were listed in another document as the CFO. So it was a mess. So we had all this paperwork that in theory should have been there for exactly this situation, couldn't use any of it. It cost each of them, by the end of it, getting straightened out, over $100,000 with the IRS. It caused the embezzler over $750,000 in damages awarded by a court. They ultimately had to close the company. Ultimately, the embezzler had his other company closed. It was a completely and utterly avoidable disaster. So that's what the documents that don't reflect you and don't get reviewed can do, is they are just a waste of time and a useless piece of paper. And that's also why, so first, if you work with anyone at all, always write down the nature and extent of the relationship. Second, don't assume that things will always be good. These 2 people had worked with each other for over 30 years, and that was the way that ended. So it's always better to write down the way that you want things to go before they get bad, because if your relationship is good now, you can both be rational people about that. Always have an attorney review your documents to make sure that you don't have those contrasting things, and to make sure you're not giving away the farm as far as those things go. And then review your own documents on a regular basis to make sure that they still reflect the nature of the relationship, that they're still consistent. Those are my points. Any final questions for people so that you can now go dwell and take some sleepless nights off of these scary stories I've told you? I'm joking. Please don't take sleepless nights. Instead, call your SBDC and set up some meetings. Unlike ghost stories, we can actually handle the scary aspects of these ones. So yeah, any final questions?
Yes, a question came up that really relates to the scenario you were just explaining. And they ask about if the SBDC has resources for, or like sample agreements that they can then take and personalize for their own business. You mentioned, you know, how it led to a bad situation when they just found them online and tried to personalize those. If someone were to make an appointment, is that something that you can help them through with those sample agreements?
To an extent. So the problem with samples is the same problem with getting things online. They haven't been reviewed by an attorney for your particular situation in your business. So that you're still going to have that same problem. When I am consulting with the SBDC, I cannot review or edit documents for you. I can absolutely walk through the sample documents that you have, talk through your business with you, and help you issue spot for questions that you might want to think about being in there and how to do that. But I cannot, in my consultant hat, actually make those edits for you. That's providing legal advice. However, if you were to sign up for an SBDC consultation, we talk about that and you're overwhelmed by some of those issue spotting, some of those discussions, we can always talk about what that would look like to hire my company, to hire Polaris Law Group to help you with those, or any of our other SBDC referral attorneys. There's a bunch of us who like working with small businesses. We understand the problems that you're going through, and we want you to have a very personalized business experience.
Great, thank you for clarifying that. And then last question we have right now, obviously we've seen how important it is to have agreements. How formal do agreements need to be? Do all agreements need to go through an attorney and accountant, or can it be as simple as having some kind of written documentation? What is that extent there?
Sure. So I will tell you, one of the first lessons that they teach us in law school in contracts is a person selling their firm on a napkin. And it was enforceable because it had all of the crucial elements of a contract on that napkin. So do you have to have an attorney review your contract for it to be enforceable? Absolutely not. And always, even if you do have an attorney or an accountant review it, you should always make sure that you understand the language that is in your voice and that you will be able to explain that contract to the people you're making the contract with, whether that's your clients or your fellow contractors. It is helpful to have an attorney review your contracts to make sure there's nothing that you're missing and to make sure you're not shooting yourself in the foot for later. It can be helpful to have your accountants review contracts that involve different tax situations. So sometimes accountants may prefer to see your independent contractor agreements to make sure that you're actually using an independent contractor and that this isn't an employee that will come back and bite you later. In that particular situation, the importance of having the accountant review things was that it said in their agreement how they were going to file their taxes, but they never communicated that with their accountant. So it's a judgment call. It's a have the people review it that need to be on the same page with you. But can you make a perfectly enforceable contract without those people? Yes, there's just a risk that you might be missing something or that there might be a better way to do something.
Great, thank you, very helpful. Well, those are all of our questions. So thank you, Samantha, so much for all the information today. I think we all have a good takeaway that we should have agreements in our businesses, loud and clear. So that was great. And thank you everyone for joining us. If you do have further questions and want to dive deeper into your agreements or get those set up, you can make an appointment through our website, which is northmetrosbdc.com. And again, the scheduling link is in the chat, so you can get those set up. They are free, great resource. They're happening virtually right now, so really easy to get that set up. So thank you all for joining us. Thank you, Samantha, for the information, and I hope you all have a great rest of your day.
Thank you guys. Happy Halloween.